session.
Thank you. Be seated. Good morning. Now is the time set for oral argument in cause number 1 CACV 18-0200, Michelle Holcomb and 4 FORE Peaks Sales Group versus Arizona Department of Real Estate. For everybody's information, the proceedings are being both audio and video recorded, and I would imagine about the year 2300 we will not be telling people that anymore because you can assume it. But barring any unforeseen problems, you can critique yourself on YouTube in a couple of weeks. How's that for information? Counsel, each side will be entitled to 20 minutes. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to save any of your time, of your 20 minutes for rebuttal, please let us know. We will make an effort not to just take up all your time. How's that? But ultimately it is your responsibility to save yourself some time. We've reviewed the briefs. We've conferenced the case. We are well aware of the facts and issues attendant to the argument. We tell you that so you can figure out how to fashion your best position and your best argument around the fact that the facts are fresh in our minds. Counsel, when you come to the podium, I'd ask that you state your name and who you represent for the record. And with that, appellant's counsel, it's all yours.
May it please the court, counsel. My name is Richard Holper, and I represent Michelle Holcomb and 4 Peaks Sales Group, LLC. They were the licensees of the Department of Real Estate. Michelle Holcomb was the designated broker for 4 Peaks, and 4 Peaks was a real estate brokerage firm. Ms. Holcomb is present in the court along with her husband, Gary Holcomb. Ms. Holcomb was a realtor and a broker for 25 years. Never had one complaint, one sneeze at her from the Department of Real Estate or any other Department of Real Estate until this matter. We're here today, and I'm going to ask this panel and this court if it would please reverse the decision of the Superior Court, the final judgment confirming the ruling of the Commissioner that the licenses should be revoked, which is the administrative death penalty, and that the failure of the Commissioner to grant a motion for rehearing or review should be vacated, as well as the cease and desist order, which is attendant to all of this, where they were ordered to cease and desist. Why are we here? I suppose the court would like to know the basis why we're going to be here. We're here because under the statutes and the rules, and under federal and state due process, we believe that there are a number of errors in this proceeding. First of all, it really wasn't a proceeding in the sense of the administrative process. The administrator herself, the Commissioner, makes the administrative decision. The AG's office doesn't do it. The enforcement staff doesn't do it. The Commissioner is tasked with doing it. Here, there really wasn't that process, which we will point out. Whatever process there was is not consistent with Arizona law or rules. It's not consistent with federal or state due process findings. Second of all, we believe that the actions of the department and the Commissioner in connection with the adoption of the rulings of the administrative law judge and in connection with the denial of the motion for rehearing or review were arbitrary, capricious, and an abuse of discretion within the meaning of applicable Arizona case law. Third, we believe that the record reflects that the revocation was not supported by substantial evidence and should be reversed. Fourth, we suggest that the penalties of revocation were so disproportionate to the alleged offenses in light of the circumstances that they truly are shocking to the overall sense and just completely out of line with previous case law And finally, we make an argument that deference, the judicial doctrine of providing deference to the administrative decision, which is Administrative Law 101, need not be applied and should not be applied in this case. Now, let's talk about the process first, and then I want to go to whether the evidence supports the findings, etc. The administrative process is a number of parts. It starts out with the department doing an audit. It proceeds, if they can't make a deal, to the administrative law judge. The administrative law judge makes recommended findings.
Well, there's a step in the middle there, right? There's compliance with the audit.
There is the audit and compliance with the audit.
There wasn't here.
Not completely, Your Honor, and I'll get to that because there was compliance with the parts of the audit that she was provided.
Well, what does that mean?
Yeah, what does that mean?
What was she provided and what did she comply with?
The audit started in October. On October 20th, the department served a subpoena. They didn't serve it. It was never served. The department admitted it in the cease and desist order. It was sent certified mail. It was never served. That's the first part. It's very difficult for a party to comply with a subpoena that's never served. They followed up.
Are you saying your client never had notice of the subpoena?
She never had notice of the subpoena.
We're sitting here talking about it today. When did she get notice of it?
She did not receive notice of it. That's the problem.
No.
Did she know
She
that-
knows about it now, right?
Knows about it now, certainly, because we've argued about it in connection with the motion. Now,
When did she first receive notice of it?
I do not know when she did, not until we were involved, which was after the commissioner issued her administrative order in April.
Well, so the subpoena sought documents. Is that fair to say?
The subpoena sought documents. I've reviewed.
Did your client know that the department was seeking documents? Short of a subpoena, just seeking documents?
Yes, there were emails, and yes, she did not comply with those emails. But look at the timing. The subpoena came out 15 days after the audit was opened. So she did.
So your argument is that your client didn't comply with the subpoena because she didn't know it was there, and she really had no legal obligation that we should recognize her today?
Oh, my, no. She has a legal obligation.
Other than the subpoena.
Other than the subpoena, yes. She certainly does.
Oh, she does?
Yes.
And she didn't comply with it?
She did not comply with that, yes. She attempted to comply. She attempted to obtain an extension. It was not granted. She attempted to put the documents together, and then the department went silent. They alleged they sent a subpoena. They had been in communication any number of ways by email. They send the subpoena. They acknowledge it's never served. They never follow up with her saying, excuse me, we sent you a subpoena. You've got to comply with it.
So if there's an ongoing audit and they're in regular contact via email about what documents need to be provided, it's your position that your client really isn't under an obligation to do that until there's a subpoena duly served?
No, that is not my position, Your Honor. My position is, as I will articulate, that to a certain extent, she did not comply with some of the duties that she had to promptly provide documents to the department when they were requested. However, the scope of what she did not do does not justify the imposition of the death penalty in light of the circumstances.
Okay. So maybe we should talk about that, because that's a very different argument than the service of a subpoena.
It absolutely is. But my point is simply to illustrate that the state has gone out of its way before the administrative law judge, before the commissioner, before the Superior Court, and in its brief to this court, to enter into the time-honored poison the record just a bit. And they have trumpeted that she didn't comply with the subpoena, that she didn't comply with the cease and desist order. And those 2 points, but then they go ahead and say to this court in the brief, well, that doesn't make any difference because the Superior Court didn't really find that it was material that she didn't comply with, that they didn't serve the subpoena.
All right,
but they use that.
I mean, I think the question of compliance we've addressed, whether it's complying with a subpoena or whatever informal dialogue.
Correct.
So let's move on and talk about either the penalty or I think you would maybe call it the quality of compliance.
I'm going to, and I am going to ask that I reserve a few minutes for rebuttal to this. That was my apology for not doing it.
Well, let's get to that now then, because time
Okay,
is
I will.
ticking.
The process. The process resulted in the ALJ issuing proposed orders on April 3rd. They were provided to the commissioner on April 4th. The statute says, the statute says under 12901, commissioner has 30 days to review all of this, review the evidence, review the record, et cetera, and decide. On April 5th, the next day, the commissioner issues a ruling affirming the ruling, the findings of the ALJ. There was no review. She didn't even say she reviewed anything. In the order, she says, I reviewed the findings of the ALJ, and I affirm them.
Yeah.
Then, our statute
You're
says,
inferring from the fact that there was only one day of review that there was no review?
I am, yes. How could there be a review when because if she had reviewed the record, she would have found there's evidence that directly rebuts the findings.
We review special actions in this court the same day, often within the same hour.
And juries are out on capital cases for hours
Understand that?
with the real death penalty.
And there's a second level. If a party does not like what the commissioner does, there is a motion, a Rule 428-1310, and that's what the parties do. Now, in the order,
Are you really suggesting, though, that we should reverse because we find that the commissioner acted too quickly?
no, I'm
Or that she
suggesting,
misrepresented when she said, I have reviewed the record. We need to dig into that issue of, did she really review the record? I mean, is that what you're suggesting?
she could not have reviewed the record. It would be physically impossible for her to have looked at the record because the record does not support the findings. If she had looked at the record,
All right, so that's your argument. It's not that it's physically, or we should make some sort of assumption that she didn't do it because she didn't have the time to do it. You're talking about the record. The record doesn't support the decision. So,
Correct.
So,
and then we made a motion. We made the appropriate motion for a rehearing or review. Now, the state says the commissioner need not review anything that's presented in connection with that. But what was presented in connection with that? All of the records had been maintained. With a couple of exceptions, and I'll be happy to illustrate.
Well, aren't the exceptions the thing that kind of eventually takes over the product otherwise?
Well, it
Don't
could
the exceptions
be, but
kind of subsume
but what
everything else?
wasn't maintained, the personnel files, there was one employee, and so she didn't. Now,
How about records of money transfers?
they were all provided. CR23 shows what was provided to the commissioner before she ruled on the motion for rehearing.
So
All of
the
those
files-
records were maintained, and there were no rental properties.
So the files then that where there were earnest money receipts missing and transactional documents missing, those were all cleaned up, found, and well ordered by the time this came to the
They
commissioner?
are. They were provided, and if you take a look, Your Honor, it's in the record, it's CR 25. All of those documents were provided to the department before the commissioner ruled on the motion. Whether they were provided to the commissioner, I don't know. But they said, CR 23 and CR 25, that they were all provided, and attached to CR 25 is an email from the Attorney General's office representing that those records had been received. Some things were not provided. Several reports, the department maintains those. She did have the earnest money checks. The agents had the earnest money receipts. She now has them, and she
finding that
provided them.
18 files were missing earnest money receipts is simply wrong.
No. The finding that they
Files were missing earnest money
at the
receipts.
time that the ALJ ruled, at the time the commissioner ruled, they had been provided to the department. And the commissioner, see, the rule that makes the motion for rehearing,
Well, let me just ask you a very simple question.
Mm-hmm.
It's not that complicated. The department asked for 20 files. 18 of them, by the end of this process, appear to have been missing earnest money receipts. Are you telling me that all 20 had earnest money receipts and that finding is erroneous?
They had earnest money checks, and at the time the ALJ ruled, they had not been provided to the department. At the time the commissioner ruled, and she's the decision maker on the motion for rehearing or review, they had been provided.
All 20?
Yes. All of the affidavit, which is CR23, reflects that Ms. Holcomb has now compiled all of the documents and has provided.
Well, it sounds, counsel, like I think you use the passive voice there. She didn't necessarily have certain documents, but she went to somebody else who did have it and got them. And is that what the regulation requires?
The testimony was this.
That you need to be able to react and track down documents almost as if it's some sort of discovery in civil litigation?
Yeah.
Or did she have to maintain the records within the four walls of her business?
The records in question, which are the earnest money receipts, the testimony was from the department's witness, that's no big thing, that any broker can get them from the title company. It's easy to do. That's specifically his words.
Okay, so easy, I don't think that answers the question. Does the regulation require the broker to maintain those records?
Yes.
Okay.
So there was a violation. And
There was. I'm standing here admitting there were violations. What I'm saying is the violations don't rise to the level under the circumstances that justify the death penalty.
What do they justify?
We put it in our motion for rehearing and review. They justified continuing education. They justified a supervision by the department. They justified perhaps a financial penalty.
Grounds for rehearing usually don't include failure to submit evidence in the first place. Evidence that could have been submitted before the evidentiary proceeding, but wasn't, usually don't justify a second bite at the apple. Are you aware of any authority that contradicts what I just said?
The rule is not just a motion for rehearing. It is a motion for rehearing and review of all previous actions by the commissioner.
Previous, yes, but not newly submitted evidence.
By the commissioner, Your Honor. The commissioner's action was twofold. One, in affirming the actions of the ALJ, and two, in denying the motion.
We're running low on time. Let me ask you to address the cease and desist order, which, as I understand it, was delivered, signed for by Four Peaks, but just never opened. Is that an accurate impression?
There is no record, nothing in the record with respect to the order for hearing. The state did not include any notice of hearing.
I asked you about the cease and desist order. I asked you about the cease and desist order.
There is.
I asked you a very specific question about
the order. The record reflects CR23 that Ms. Holcomb did not see the cease and desist order. Now, you would say that's self-serving, but it's supported by two bits of evidence. One, the order was issued.
The question wasn't whether she saw it.
I asked you a very specific question. I just want a yes or no answer. Was it signed for by a Four Peaks employee and not opened? Yes or no?
It's two questions.
Would you answer both of them, please?
Yes. The first answer is yes. The second is no. Because
so it was opened.
It was signed for. That's the yes answer. I do not know if it was open. Ms. Holcomb never saw it. So I don't know if it was open. I can't answer your question.
So it's the processes within her office that failed, in that after it was signed for, after it was sent, after it was signed for, after it was received, it just laid there. No one took the knife and opened up the envelope.
I don't know that. She didn't see it.
But you do know she had it.
No.
She signed for it but didn't have it.
Your Honor, I didn't represent. Nobody represented Ms. Holcomb until after the.
Well, you represent her here today.
I do represent her.
We need to make a decision on that record.
She has filed an affidavit with this court that she has never seen it. I have no reason to believe that that affidavit is false. Now, what did the state, why is this so important? There is a very important document, and that document is the state's audit, because the finding of the ALJ and the finding of the commissioner was that Ms. Holcomb failed to adequately supervise her brokerage firm, and the statute requires her to do that. Exhibit 6 at the administrative law hearing, which is CR43, is the audit of the state. On page 2, there is a check the box. Has the broker has exercised proper supervision? The audit checks the box, yes. The audit is signed by the person who testified at the hearing. There is no evidence that Michelle Holcomb did not adequately supervise her brokerage firm. Now, the state argued to the Superior Court.
What about not keeping track of cease and desist orders? Isn't that evidence of inadequate
I'm
supervision?
sorry, Your Honor, I didn't hear you.
Well, a cease and desist order comes from the department into the office. It's signed for by an employee and nobody reads it. Isn't that evidence of failure to supervise?
No, the state would say it's a failure to comply with an order of the commissioner, which is a different thing. There's two points to that, though. First of all, the order was issued on December 6th. There was no follow-up. They'd been in touch with her by emails. There was no follow-up about whether she got it or not. Nobody came out to check if she was still operating.
It was signed for. How much follow-up did they need?
Well, if you are concerned that there is harm to the public and you issue a cease and desist order, you'd think you'd go out and check and see if she's complying with it.
Well,
they did.
Give us some authority for that. Because my recollection is that once you're served, once they get back their receipt, everyone is entitled to assume that you know what's going on, that you have received notice and you are expected to comply. Now you're telling me that there's a new service follow-up requirement, that they have to call you a couple times to make sure you remember getting it?
If there's public importance, is that?
No, due process requires that there be adequate notice.
Do you have a case for me on that?
I have facts for you on that, which is this, Your Honor, if I may. The subpoena was issued. The department knew it hadn't been receipted for. The order to show cause, or I'm sorry, the cease and desist is issued, and the department sends it by certified mail. They don't follow up. They wait till after the time to appeal runs, 30 days to follow up, and they continue her license in the active status on their website. She checks the website, it's in her affidavit, finds her license is active, and just assumes there was nothing to interfere with that.
Thank you, counsel. We're out of time.
Now, I'd like a couple more minutes, Your Honor, because I've responded to basically 15 minutes of questions.
We'll give you a minute.
Thank you. The cases we've cited are quite clear.
Do you want it on rebuttal or now?
Oh, I'll take it on rebuttal, Your Honor. I like it any way that pleases the court, but I'll take it on rebuttal.
Thank you.
Very well.
Thank you.
May it please the court, my name is Lynette Evans. I'm an assistant attorney general, and today I'm here on behalf of the Arizona Department of Real Estate. Your Honors, a professional license is a privilege that is granted with the understanding that the licensee has certain responsibilities. One of those responsibilities is that the licensee will respond in the course of an investigation. And this is an important...
Do there need to be follow-up calls? If they don't respond, is there a rule, is there case law that says it is your obligation, if they do not respond as required, that it's your obligation to check with them a couple times?
No, Your Honor, that is not a rule, a requirement, or any case law that says that. In this case, the department went above and beyond to try to communicate with this particular licensee, to try to let the licensee know about the information they were seeking, and to give the licensee additional opportunities to provide that information. And unfortunately, the licensee chose not to respond to those additional requests for follow-up information.
The follow-up calls.
Correct.
Go ahead, please.
And so the purpose of the department, so basically this is a real fundamental responsibility of the licensee because it goes to the heart of what the licensing agency's job is to do, right, which is articulated in ARS 32-2102, which directs the department to administer and protect the public interest through the licensure and regulation of the real estate profession in this state. So when a licensee fails to respond, it basically makes it impossible for the department to carry out a complete investigation and ultimately to fulfill its primary obligation, which is to ensure the protection of the public by following up with licensees and making sure that those licensees are complying with the laws.
So is it fair to characterize the offense as one of record keeping?
I think it is more than just failure to keep records. I think
All right,
that
so let's identify exactly. We have record keeping and what else?
So we have initially obviously the record keeping, but then it was also the failure to respond to requests for additional information, to respond to a cease and desist order, to, again, provide those additional information, to not appear for a hearing. All those things, it just lays out, again, all the department's efforts to work with the licensee so they could complete their audit.
Let me ask you, if it was just record keeping and we didn't have this sort of dilatory or noncompliance, would revocation be appropriate?
I think record keeping is critical. It's critical to the real estate profession. It's important that a broker maintain these. So we're talking about earnest money receipts. We are talking about the cancellation of contracts. It's certainly sometimes the record can be somewhat less important than another, but in this particular case, I would also argue that the records at issue, at question, are also fundamental. So a failure of a licensee to even have those records, and I think you asked a question earlier about the laws. The laws require that the licensee maintain those records at their place of business at all times.
The council said it's easy enough to go to the county recorder's office and get them. And so there was no obligation to maintain a complete file at the office.
Right.
That's the way I understood the response anyway.
Whether or not it's easy to get those records from other locations, the fact is that this is a real estate licensee, and the commissioner has jurisdiction only over that real estate licensee. So when the commissioner or the commissioner's representatives arrive at the location and ask for those records should be available. Now, in this case, the department was trying to work with the licensee. Even though she didn't have those documents at the time of the audit, she allowed additional time past the audit for the licensee to get those documents to the department, even though we could have a theory, right, because the law demanded that those records be presented at the time of the audit.
So this is, I would expect, a fairly common offense, one of record keeping in the real estate brokerage context?
I'm not sure if
As you receive counsel for your client, I mean, what's the most frequent complaint you field?
I certainly see. We do see, frequently that licensees won't have a complete record of the transactions. They'll be missing some information.
And do you typically, when you have the scope and the quality of I guess, non-record keeping, would you typically, and have you, moved for revocation of licenses as a matter of course?
Yeah, well, so for example, in this case, we didn't immediately go to a revocation, right? There was a series of emails, there was voicemails, there was a subpoena, there was a cease and desist order. This is a very slow escalation of events by the department's perspective to try to get these documents. Certainly in this case, obviously, we didn't go from day one of not having the documents at the audit to a revocation proceeding. There were multiple attempts to try to receive this information. Yes, Your Honor.
There was a hearing in March at which the appellant did not appear.
That's correct, Your Honor.
How was the notice of that hearing served?
Yeah, that notice was sent by certified mail to the address of record for the licensee.
Was it ever signed for?
That notice, I'm trying to remember if that one was signed for. I believe. Apologize, I don't have that information in front of me. I know that the cease and desist order was signed for by a representative at the brokerage.
Okay.
Counsel, I got a question for you. You send a notice out that we're going to come to the office on such and such a date, and we're going to audit your office, audit your files, whatever your language is. Correct?
Correct.
You send out a notice. They're made aware of it at that point.
Correct.
Okay. Having then noticed the hearing, do you need to send out a second notice that says, by the way, you need to be in compliance with the condition of your files, with the records of the office? Do you have to send a second one out telling them what you expect from them when you show up at that audit?
No, Your Honor. As part of the responsibilities of being a licensee, you're supposed to know and understand the laws that govern the profession, including what the record-keeping requirements are for being a broker and maintaining those records at the brokerage. So, no, there's no requirement that the department follow up or provide additional information about what's required of the licensee at that time.
So if the licensee, when you show up, just simply says, hey, there are the files, take them or leave them, is that an adequate response?
No, I think that, again, the licensee should be aware of what their requirements are and what they're supposed to maintain.
They need to be in compliance, ultimately.
That's correct, Your Honor.
Whose responsibility is compliance?
That's the licensee, absolutely.
Thank you.
So basically, the three questions, of course, before this court is, one, is there sufficient due process? And then, of course, is there substantial evidence to support this determination that the licensee had violated the real estate statutes? And finally, the question as to whether or not the revocation was an appropriate penalty for those violations. So without going into a whole lot of detail about the timeline events, what I can tell you is that in total, the department staff met with Ms. Holcomb in person twice. They sent 6 emails. They left several voicemails. They finally issued a subpoena that turned into issuing a cease and desist order, and then they issued a notice of hearing. And finally, they entered the revocation order. Yes, Your Honor.
Let me ask you about your colleague mentioned a document, some sort of checkbox, audit checklist maybe, and that it said, does this broker exercise reasonable supervision? And the auditor said yes on that document. Is that correct?
I believe the auditor did initially check yes on that document. And that was, again, before they were giving the licensee, first off, additional time to present records that were not presented at the time of the audit. And it wasn't until after the audit, several days after that, when they still had not received the documents that the licensee said that she would present, that they started to run into these problems with the licensee not following up, not providing the information the department had requested. But yes, that initial document did check yes.
So again, it's sort of a similar theme. What started as a sort of a discrete record-keeping offense sort of expands with noncompliance, and what was checked becomes unchecked.
That's correct, Your Honor. And I think there's a certain amount of willingness on the department's part to try to work with the licensee, to understand that perhaps at the time of the audit, for whatever reason, they weren't prepared, despite the fact that they're required to do that. But the department was willing, and in this case did, give additional time to try and give the licensee an opportunity to comply.
Well, and ultimately, by the time of the motion for rehearing, were all of these files cleaned up?
I'm not sure I would agree with that. I think there was some additional information that was provided, but it's my understanding that not all of the information had been submitted to the department at the time.
Okay.
So basically, the department used every tool available to them to try to get this licensee to respond, and they made numerous attempts to obtain the documents they needed so they could complete their own audit. We only sought revocation and disciplinary proceedings after Ms. Holcomb repeatedly ignored those requests. So with that kind of background information,
It seems to me like we take an incident and everything that follows and we make it sound like it's an incident. In fact, isn't it the case that there is a problem? The files aren't complete. You go out, you do your audit, and you give her time to get the files complete. She doesn't respond. She doesn't send you the stuff. She doesn't bring them into compliance. And then isn't that how we got to the cease and desist order in the first place?
that's correct.
After things were noticed, they weren't complied with, there were promises made, they weren't complied with, there were calls made, they weren't complied with. So we got multiple events here. This isn't just the files weren't correct, or the files weren't complete. Is that fair?
That is fair.
Thank you.
Absolutely. And, Your Honor, to go back to you asked an earlier question about the licensee, about whether or not the notice of hearing was signed for, I can say this. There was an affidavit that was provided as part of the request for rehearing, and in that affidavit, what the licensee said was, and quote, "By the time I received the notice of hearing, I was not emotionally able to respond. I admit the failure to do so and take responsibility for not doing so," end quote. So that was the licensee's information about her understanding of the notice of hearing.
Thank you.
So sorry, to go back. So basically, as everyone understands, the elements of procedural due process are notice and opportunity to be heard. So both the subpoena and the cease and desist order were sent, again, by certified mail to Ms. Holcomb's address of record. Apparently, she ignored the notification that came from the post office and chose to never pick up the subpoena. The cease and desist order, again, was sent also by certified mail, and as you all know, that was signed for by an employee of the brokerage. But according to that affidavit that was submitted, again, she did not open that until after department staff came out and visited her brokerage. Now, the department also sent the notice of hearing complaint by certified mail to that same address of record. So again, based on her own statements, it appears that she chose not to, because of her emotional state, not to participate in that hearing. And then it wasn't until after that revocation that she filed her request for rehearing. Now, the commissioner considered that request and determined that there were not grounds to grant it. Now, Ms. Holcomb...
Can we fault a commissioner who says, I've reviewed the record, but we really don't trust that as being accurate?
No, Your Honor, I would say absolutely not. I think there's no evidence to support any kind of conclusion that she didn't review the record, that she didn't do her job. And being efficient, I think, shouldn't be seen as a negative on the part of the commissioner.
Can you give me any authority indicating otherwise?
No. There's no authority that I know of that says that the commissioner has to review it for 5 days or has to take specific, steps in order to demonstrate that she has actually reviewed the record. I think it is assumed, and correctly assumed, that a public official is doing their jobs absent some sort of evidence or case law to the contrary that says that they have not acted appropriately. So Ms. Holcomb had multiple opportunities, both formal and informal, to communicate with the department and explain what her situation was. She had notice and an opportunity to be heard. So Ms. Holcomb received sufficient due process. Now, in regards to whether or not there was substantial evidence to support the determination that Ms. Holcomb had violated the statutes, so of course the appellate court's job is to review the Superior Court's judgment to determine whether the record contains evidence to support that judgment. And if an agency's decision is supported by the record, substantial evidence therefore exists to support the decision, even if the record supports a different conclusion. Now, our real estate statutes require licensees, as you pointed out, to maintain specific records. And the department came in, had an audit, and said, please provide us those records that the law says you have to keep. Now, Ms. Holcomb was unable to provide those records at the time of the audit, and so the department granted her some additional time to provide those records. She was not able to comply and didn't provide that information. She also failed to maintain a complete record of each transaction, and so I think we've already touched a little bit on this, but we again are talking about sales transaction files, earnest money receipts, documents concerning property management activities, an employee file, a purchase contract, as well as a confirmation of 2 canceled sales contracts. She failed to produce those documents the department was asking for, and then she also failed to exercise reasonable supervision over the activities of the brokerage. So there is definitely substantial evidence in this case to support the commissioner's finding that Ms. Holcomb had violated the real estate statutes. And of course, the final question for this court is, did the commissioner appropriately impose revocation as a penalty for these violations? Now, an administrative penalty is excessive only if it is so disproportionate to the offense as to shock one's sense of fairness. Now, whether a reviewing court would impose the same sanction is really immaterial as long as the discipline imposed is within the commissioner's authority. So this case involves a very slow, very deliberate escalation of events and actions on behalf of the department with no response. For Ms. Holcomb, this was no rush to revocation. Revocation, in fact, it was the final action that the department took after multiple attempts to get the information it needed from Ms. Holcomb by other means. So after several unsuccessful efforts, her refusal to comply with the law, the commissioner was faced with really limited options here. And she exercised the authority that the legislature granted her and revoked this particular license. So just kind of to wrap this up in closing, Ms. Holcomb had sufficient due process. Now, whether she chose to read and respond to the information that the department sent to her is her responsibility. And all the department can do is send that information to the licensees. But obviously, it cannot make a licensee pick up their mail from the post office or even open that mail once it arrives. Also, there is substantial evidence to support the department's determination that Ms. Holcomb violated multiple statutes here. Now, Ms. Holcomb's attorney has argued that there was no loss to any member of the public. But that is not the standard. Nothing in the real estate statutes or the rules requires that a member of the public be harmed or hurt before the department can take action. In fact, the real estate laws exist to protect the public from harm, not from potential harm too, not merely to take action after a harm has already occurred. And the revocation in this case, again, is not in any way shocking and was certainly not a knee-jerk reaction on the part of the department. The commissioner acted within her authority to revoke the license based upon the multiple violations. Now, Ms. Holcomb's refusal to provide the information the department requested made it impossible to regulate her and to uphold the department's obligations to the public. Ms. Holcomb had multiple opportunities to explain her situation to the department, but she chose not to avail herself of those opportunities. And consequently, after a full administrative hearing, the administrative law judge recommended revocation. Now, the commissioner adopted that recommendation, and the Superior Court Judge Starr upheld that decision. The department is charged with specific responsibilities, but so are the licensees. And after a slow escalation of events, which included in-person meetings, phone calls, emails, a subpoena, a cease and desist order, the department, unable to regulate, was left with one last option, which was revocation of Ms. Holcomb's license. Ms. Holcomb received sufficient due process. There is substantial evidence to support the findings of violations, and the revocation was not excessive. Thank you.
Counsel?
Three points, if I might. The audit was introduced as State Exhibit 6 at the hearing on March 22nd of 2017. It was signed on November 2nd of 2016. At no time did the state ever say this was a preliminary report. This is the audit. The audit says she adequately supervised. Second of all, the documents were received by the Attorney General. CR25, the affidavit of the Deputy Assistant Attorney General, says that they were received. There's an email to that effect. The documents were produced eventually. Disproportionate. The two cases are Bear v. Howard, or Bear and Howard. In both of those cases, in one case, there was a felony conviction for securities fraud, which was the basis for the revocation. In the other case, there was a knowing failure to pay income taxes, which was the basis for the revocation.
So, counsel, does that mean that we have to get to the point of someone goes to prison before we can pull the license?
Certainly not, Your Honor. But where all the documents are in fact provided, and where the evidence does not support the findings, such as the fact that she adequately supervised, in those instances, then the penalty of revocation is disproportionate. It's a sliding scale. Who knows when it stops? It's when it shocks the conscience. And in this case, after 25 years, no property management going on, so there are no property management records. All the other records are sent there except the several reports they have. This should have been handled by an administrative penalty that was less. Due process is both procedural and substantive. Bias, vindictiveness, irregularity. The cases, particularly the new federal cases, show that due process requires that the rules be followed. The rule itself says that the commissioner will review whether the penalty is excessive. She did not do so in response to the motion. In fact, in her order denying the motion, she did not even reply to what the motion was. The pre-printed order form says that she's denying the motion for rehearing or reconsideration. That's not what the rule is. It's a motion for
Well, the rule, I mean, if you
rehearing.
want to talk about the need to comply with rules, the rule would also require your client to appear at the hearing.
Correct. But the fact that she doesn't, the administrative process does not end with the ALJ, Your Honor. And due
but
process
what
provides
rule-
throughout the administrative process.
Throughout this entire proceeding, what rule did your client comply with?
She complied with the rule that allowed her to file a motion for rehearing
That's not
and
what I asked.
provide
Did she
evidence.
comply with any rule associated with this entire proceeding? Did she comply with the audit? Did she comply with the cease and desist? Did she comply with the notice of hearing? I'm struggling to find one good faith effort at compliance
All right,
in
let
this
me
entire case.
let me respond to the three, Your Honor, that you've just pointed.
No,
With
but
re-
I don't mean to rehash this ground. I asked what rule she complied with. That's the question, and you're out of time.
She did comply with the audit. She
Thank
did
you.
comply with the order. Thank you, Your
Thank you,
Honor.
Counsel. All right, we're going to take this under advisement at this time. Thank you for your argument today. We stand adjourned. We will rule in due course.